who are the parties to the contract? Usually, you would think that's a pretty basic thing to get. But it can be a problem. People usually do business under the name of some sort of entity, a business that has been created. And usually in most states, if there's a business that has been created legally, whether it's a corporation or a limited liability company, that business is required to be registered in the Secretary of State. Every state has its own Secretary of State. Some of them call them a Department of State. And nowadays, most of the records for those entities are actually online. You can do an online search for the Georgia Secretary of State, type in the entity name, and confirm that that is actually a legitimate entity. And I have had this problem in the past where I've had clients actually sign contracts and they don't get paid like they're supposed to under the contract. And so then they want to enforce their contract. And then we find out that they did not actually sign a contract with a legal entity. So then it becomes a problem trying to figure out, well, who's supposed to pay? Who do you sue? A lot of companies, even though they have legal names, they also do business under what's called trade names. For example, my law firm is Sklar & Heim, LLC. Actually, Sklar & Heim, LLC. That is my law firm's legal name. If we decided to do business under a trade name, we might call ourselves Sklar & Heim or S&H. But if you actually sign a contract in which you hire us and it says that you are hiring S&H, then it makes it quite unclear as to who it is that you're actually hiring. Typically, every state has different laws as to how you're supposed to register a trade name, because companies are actually required to register their trade names. Some states require the trade names to be registered in the Secretary of State. So usually when you look up the company, you can actually look up their trade names, and it makes it very easy to confirm that a trade name matches a particular name of a legal entity. Some states, like Georgia, make it a little more difficult. Georgia actually requires companies to register their trade names with the Superior Court of the county in which they do business. And these are not usually online records that are accessible to the general public. If you want to find out whether a trade name is legitimate, you actually have to drive over to the courthouse, ask to look at their records, and dig through their records and try to find this trade name. So as a general matter, whenever you sign a contract, even if the business is using a trade name, make sure that they use their full legal name in the contract. That way it is absolutely clear who you're contracting with. I had a client who actually rented out these portable storage units. They're about the size of a trailer, and they would rent them out to various customers of theirs. Some of them were construction developers. Some of them were just businesses that needed temporary storage units. And they had rented out a bunch of those trailers to one particular company, or what they thought was one particular company, because later on when they called me and they said that they had not been paid and they were actually owed many tens of thousands of dollars, I looked up the company and saw that it was not a legal entity. So I did some more digging, and I saw that it was a trade name, but it was not a trade name that was used by one legal entity. It was a trade name used by at least 20 different legal entities. 20 different legal entities actually used the same trade name. Now, it looked like all of those legal entities might be somehow related. Maybe they had the same set of owners. Maybe one entity was what's called the subsidiary of another entity. But the only way to be able to recover from the correct entity, because of the fact that the client did not sign the contract with the legal entity, would have been to sue all 20 of those legal entities, which makes for a very complicated, expensive litigation. So ultimately, that particular client decided that it was simply not worth the expense. and they would just have to write off the $20,000 that they were owed.